Buckle up before you clip that headline and share it. Is Parliament really wiring a breathalyzer into every new car sold in this country? That's what a growing number of people believe, and I fielded that exact question 3 separate times this month alone. So let's settle it right at the start. Yes, there is a genuine law on the books. It's been active since 2022. This isn't speculation, and it isn't some proposal sitting in a drawer somewhere. But what the regulation actually states is nowhere close to what's circulating online, and untangling that gap is what this entire video is about. Here's my plan for the next few minutes. Just 2 things, nothing more. First, I'll show you 4 words tucked inside the regulation's definitions section that determine whether any of this panic holds water. They take about 10 seconds to read, and once you've seen them, that misleading headline will never fool you again. Second, I'll point you towards something that actually is sitting in your car right now that almost nobody's talking about. And if you're ever unlucky enough to be in a serious crash, it will matter far more than any imaginary breathalyzer ever could. So stick around for that second part especially. The first issue is the one everyone's anxious about, and probably shouldn't be. The second is the one nobody's warned you about, and probably should. Before going any further, let me be upfront, because this topic tends to bring out the worst in comment sections. I spent 15 years defending drink driving cases. I've also sat across from families dealing with the aftermath of one. Nobody with any sense would argue that drink driving is anything but dangerous and wrong. This video isn't questioning that. It's about the gap between what a law actually says and what people claim it says. Because right now, those 2 things have drifted miles apart. I'm a former defence solicitor. For 15 years, I represented clients in police stations and courtrooms throughout England and Wales. I'm not a politician, and I have zero ambition to become one. My job has always been reading the actual text of the law, something almost nobody bothers to do on this subject, including plenty of the people making the loudest noise about it. So let's start with the parts that are genuinely accurate, because there's quite a bit of truth buried in here. The regulation exists, numbered 2019-2144. Article 6 states that motor vehicles must be fitted with a set of advanced safety systems, 7 of them to be exact: intelligent speed assistance, driver drowsiness and attention monitoring, advanced distraction warnings, an emergency stop signal, reversing detection, an event data recorder, and, the one causing all the uproar, alcohol interlock installation facilitation. Article 19 confirms this took effect from the 6th of July 2022, 4 years back now. So, does this mean your brand new car is secretly testing your breath before it'll even start? Everything hinges on how that phrase is defined, and the regulation spells it out plainly in Article 3. A standardized interface that facilitates the fitting of aftermarket alcohol interlock devices in motor vehicles. Read that slowly again. A standardized interface. That's really all it is. Wiring, a connector point, and a shared technical standard, so a device built by one manufacturer can be attached to a vehicle built by another. The law doesn't demand a breathalyzer be installed in your car, not in anyone's car. It requires the vehicle be constructed so that a device could be added later by someone else. And notice that word buried in the definition: aftermarket. That means fitted afterward, by someone who has actively chosen to fit it. A court, an employer managing a fleet, a car rental company, a bus operator. So where did the panic actually come from? To be fair, it wasn't fabricated from nothing, it's just been compressed down. Someone reads that vehicles must include alcohol interlock installation facilitation. A few words get trimmed off the end in translation, and what's left is the claim that cars must have alcohol interlocks fitted. From there, it's a short hop to a viral headline. The regulation itself runs 100 pages of dense technical language. The headline is 9 words long. Guess which one spreads faster? That said, I don't want you walking away too relaxed either, because the other 6 items on that list are genuinely real, and most drivers have no clue they're already built in. Intelligent speed assistance reads posted speed limits, either from road signs or mapping data, and alerts you when you've exceeded them. Here's the detail nobody mentions. The same article states, just a couple of lines further down, that the system must be able to be switched off. You can disable it. It resets itself back on next time you start the engine, but you're free to turn it off each time. Driver drowsiness and attention monitoring, along with advanced distraction warnings, analyze your driving patterns, and in some vehicles, a built-in camera, to judge whether you're genuinely focused on the road. Then there's the 7th system, the one I'd actually pay close attention to, the Event Data Recorder. The regulation describes it as a device with the sole purpose of capturing and storing critical crash-related data shortly before, during, and immediately following a collision. Note that phrase, sole purpose. Based on the wording, this isn't a tracking device. It doesn't follow your movements, and it isn't logging your Tuesday drive to the shops. But in the brief window surrounding an accident, it captures a substantial amount. Your speed, whether and how hard you braked, steering movements, whether seatbelts were fastened, whether the accelerator was engaged. In effect, it becomes a witness, one with a perfect memory, no allegiance to you, and no concern for how frightened you might have been at the time. Now, the question that pops up in every comment thread under every version of this story is identical, so let me answer it directly. Does any of this apply to the car you currently own? If your vehicle is more than a couple of years old, almost certainly not. This regulation applies to vehicles being newly type approved and manufactured from that date forward. Nobody is coming to retrofit any of this onto the car already parked in your driveway. Nothing in this law reaches backward in time. There's no obligation for you to have anything installed, no inspection that penalizes you for lacking it, and no requirement to modify a car you already own. Your existing vehicle is precisely the same today as it was yesterday. This is strictly a new car regulation, which explains exactly why it's rolling out so quietly. Not as a sudden change affecting everyone overnight, but gradually, one purchase at a time, as people replace their old cars without a single word of it being mentioned by the salesperson. Underneath all of this sits one fear doing the heavy lifting, and I want to address it honestly rather than dismiss it. Could a car simply refuse to let you drive it? The honest answer? Yes. A genuine alcohol interlock does exactly that. You breathe into it, and if your reading exceeds the threshold set on the device, the engine won't start. That's precisely what it's designed to do. Not a conspiracy, just a straightforward product function. But the regulation we just examined doesn't install that device in your car. It installs the socket the device would eventually plug into. Whether an actual interlock ever gets connected to your specific vehicle is an entirely separate call, made by someone else for their own reasons. And those reasons are fairly predictable. A court imposing conditions on someone already convicted, an employer overseeing a van fleet, a car rental firm, a bus company, and in certain countries, an insurer setting terms for coverage. That's a legitimate and serious conversation to have. It just isn't the conversation that headline was pretending to start, which implied your own car was about to start testing you, with nobody making any decision at all. Now, let me show you something Britain has quietly lived alongside for years already, without a single alarmist headline attached to it. Black box telematics insurance. It's a device or app that reports your driving behavior back to your insurer in exchange for a lower premium. It tracks your speed, it tracks how hard you brake, it knows what hour of the night you're out on the road, and every bit of it is completely legal because you agreed to it in exchange for a discount at a moment when the savings felt like the only thing that mattered. Which brings me to the point I've been circling this whole time. The real pathway into your driving data in this country was never the government forcing its way in. It's always been you signing up voluntarily for a cheaper premium. What changes once this equipment comes standard in every new car isn't that surveillance suddenly begins. It's that the thing you used to opt into voluntarily is now simply present in every vehicle, whether you agreed to it or not. So here's the real question, and it's not the one from the headline. It's not, will my car test me? It's, who's allowed to ask what my car recorded, and what am I obligated to hand over? And honestly, that question is far less settled than the technology itself. The hardware always arrives first. It usually does. What I can tell you is the rough shape of the situation. Data stored inside your car isn't the same thing as a statement made by you personally. A machine isn't a witness you can cross-examine, and it isn't evidence you've consented to provide. And one line hasn't shifted an inch. Whatever your car recorded, you still aren't obligated to explain yourself at the roadside. So who actually owns that data? I'll be straight with you rather than pretend there's a tidy answer, because there genuinely isn't one yet. You purchased the vehicle. The manufacturer designed the recording system and, in many cases, holds the technical key needed to read it. Your insurer would love a copy, and a court has the power to compel production of things nobody particularly wanted to hand over. 4 separate parties, all with an interest in the same set of numbers, and no clean, tested answer yet about who gets access and under what conditions. Which is exactly why this deserves 20 minutes of your evening. Not because you can change any of it tonight, but because you can't ask a single meaningful question about something you don't even know exists in your car. Let me walk you through how this actually plays out in a real case, because it's far less dramatic than the headline and far more useful to understand. Nobody is streaming footage anywhere. Nobody is sitting in a control room watching you drive live. The car simply holds a small snapshot of data covering a few seconds, and it just sits there, dormant. Then a serious collision happens. The vehicle gets recovered and examined. A technician with the right tools extracts that data module, and what was previously just numbers stored in a chip becomes a printed document showing exactly how fast you were going. That document then gets compared against whatever you said at the roadside on the night, shaken, rattled, and trying to be cooperative. Which is exactly why I always advise against narrating your evening's events to anyone at the scene. That was sound advice back when it was simply your word against the officers. It's even more important now that there's a second account sitting inside the car itself, one that never gets scared and never misremembers. I want to put this in perspective, though. The powers police already hold at the roadside dwarf anything contained in this regulation. They don't need your car to test you for alcohol. They've had the authority to test you directly for decades, and refusing that test is a criminal offence in its own right. The legal limit itself comes from Section 11 of the Road Traffic Act: 35 micrograms of alcohol per 100 millilitres of breath, 80 milligrams per 100 millilitres of blood, 107 milligrams per 100 millilitres of urine. That's the figure that determines whether you've broken the law, not anything stored in your dashboard. It's the handheld device at the roadside, then the machine back at the station. Now, here's the part one I think genuinely does matter, and it has nothing to do with policing at all. For essentially the entire history of driving, up until roughly a decade ago, how you drove left absolutely no trace. Speed down an empty road at midnight, and the only witness was you. Unless someone happened to see it, it simply didn't exist as far as any record was concerned. That's the thing that's quietly disappeared, and not because of some breathalyzer law. It ended because recording equipment became cheap enough to fit into every vehicle rolling off the production line. Your speed, how hard you brake, what hour you're driving, how long since your last break, all of it now measurable in ordinary cars owned by ordinary people. And behaviour that can be measured has a habit of eventually becoming behaviour that gets priced. That's not a prediction about government overreach. It's simply what's already happened in every other area where data became cheap enough to collect. So what should you actually do with all this? 3 simple steps, nothing dramatic. First, find out exactly what's fitted to your own vehicle. It's listed in the handbook, in the section nobody ever opens, and it will tell you which of these 7 systems your car has, plus how to switch off the speed warning feature. Second, if you're ever involved in a serious collision, assume the car holds its own record of the final few seconds, and mention that to your solicitor on day 1 rather than day 90. And third, the one piece of advice that hasn't changed and never will, at the roadside, cooperate physically but stay quiet verbally. Provide your name, your address, your documents. Blow into the device when legally required to do so, and don't narrate your evening to anyone. There are 2 ways people tend to get this wrong, pulling in opposite directions, and I've encountered both this month. The first person decides the government is installing breathalyzers in every car, gets furious, shares the headline, and stops paying attention entirely. Because the specific claim he's angry about turns out to be false, the moment someone shows him the actual definition, he assumes the entire topic was nonsense, real parts included. His instinct was right, his target was wrong. There genuinely is something worth understanding in that car, it just isn't the breathalyzer. The second person does the sensible thing, checks the facts, discovers it's only an interface, concludes the whole story was invented, and relaxes completely. Now he believes there's nothing new in his car whatsoever, which also isn't true. The reality sits squarely between these 2 positions, which happens to be the least shareable, least clickable place for a fact to live. Less dramatic than the headline claimed, but considerably more significant than nothing at all. So, let's bring it all together. The regulation is real, and it's been enforced since 2022. What it actually requires regarding alcohol is a standardized interface, a socket, allowing an aftermarket device to be fitted by someone who has chosen to fit one. It does not install a breathalyzer in your car. The other 6 systems on that list are real, and they're already present in the vehicle. The one genuinely worth knowing about is the event data recorder, because in the moments surrounding a crash, it functions as a witness. And despite all this new equipment sitting inside modern cars, the oldest rule of all hasn't moved an inch. You still don't owe anyone an explanation at the side of the road. If you found this useful, the pinned comment has the article numbers, so you can go read the regulation for yourself, rather than take my word for it. And subscribe, because every week I break down another one of these stories in plain English. Keep it calm, keep it brief, and I'll see you in the next one.